So we'll continue with the Companies Act, mode of registration and incorporation of company. Now, when a company wants to register, there are some people who will be promoting the company. They will be issuing the share prospectus. Their names will be mentioned in the prospectus, right? They are the people who are going to take the company forward. So these are promoters. Companies Act 2013 defines the term promoter under section 269, 2 subsection 69, which means a person who has been named as such in the prospectus or is identified by the company in the annual return referred to in section 92, or who has control over the affairs of the company directly or indirectly, whether as a shareholder, director, or otherwise. So your promoter can be any person. Your shareholder can be your promoter. Then your director can be your promoter. In accordance with whose advice, directions, or instructions the board of directors of the company is accustomed to act. Who is going to guide the people of the company how they have to act? The directors will act according to them. Then the employees will act according to them. Right? So if we consider for Reliance, who will be the promoter? Mr. Mukesh Ambani. Right? In simple terms, we can say persons who forms the company are known as promoters. People who come together and form the company are called as promoters. It is they who conceive the idea of forming the company. They are the people who get the idea that we need to form a company. They take all necessary steps for its registration. So for the registration of the company, they take all the necessary steps required. It should, however, be noted that persons acting only in professional capacity, example, solicitor, banker, accountant, etc., are not regarded as promoters. Any lawyer has helped you, solicitor has helped you, banker has helped you, accountant helps you where you should make the place of business, where you should be situating the place of business, how you should go on, what forms you have to fill. All these, if a chartered accountant also forms you, they are not regarded as your promoters. Is promoters clear to you?
Yes, ma'am.
Let's go ahead. Formation of company. Section 3 of the Companies Act 2013 deals with basic requirement with respect to constitution of a company. In case of a public company, any 7 or more person can form a company for a lawful purpose by subscribing their names to the memorandum and complying with the requirements of this act in respect of registration. So it says that section 3 says how a company will be formed. For a public company to be formed, there should be 7 people who are going to come together and they are going to do some lawful business. The purpose of the business should be lawful. They should write their names in the memorandum and they say that we are going to comply with all the regulations of the Companies Act. Then only you can say that a company will be formed. In same way, 2 or more persons can form a private company and one person can form the one person company. So for public company, again, they have given 7 or more person. Private company, 2 or more person. One person company, one person is required. Okay. Now, Section 7 of the Companies Act 2013 provides for the procedure to be followed for incorporation of a company. Section 7 tells us how a company will be incorporated. Filing the documents and information with the registrar. For the registration of the company, following documents and information are required to be filed with the registrar within whose jurisdiction the registered office of the company is proposed to be situated. If we are forming a business in Mumbai, a company in Mumbai, so then we have to go to ROC of Mumbai. Right? We have to reach the ROC of Mumbai. We have to go and file all the documents. Also, there is online document uploading allowed. If you want, you can go and visit that company, visit the office also. Memorandum and the articles of association, articles of the company duly signed by all the subscribers of the memorandum. So it is to be signed by all the people who are going to take part in the company formation. They have to sign the memorandum and the articles. We'll be seeing what is memorandum and articles of company. A declaration by a person who is engaged in the formation of company. It can be an advocate, chartered accountant, cost accountant, company secretary in practice. A person will have to declare, okay, these people are trying to form a company. And by a person named in the articles, director, manager, or secretary of the company, that all the requirements of this act and the rules made thereunder in respect of registration and matters precedent or incidental thereto have been complied with. They have to give a declaration that this company ABC Limited, which we want to form, has complied with all the all the requirements of this act for registration. Who is going to give the declaration? One, your CA, CS, CMA, or a lawyer can give the assent, can give the declaration, along with a declaration by director, manager, or secretary of the company, right? They have to give a sign and they have to declare that, okay, we declare we are going to comply with all the requirements of the registration, and we have already also complied with all the requirements of registration. Okay. Then we have a declaration from each of the subscribers to the memorandum and from persons named as first directors. So we need a declaration from first directors also from the people who are subscribers of memorandum. That is your promoters here. If any, in the article stating that he is not convicted of any offense in connection with the promotion, formation, or management of the company. He is not convicted of any offense in connection with. He is not done something wrong. Convicted of any offense means done some illegal work to form this company. He has not been found guilty of any fraud or misfinance or any breach of duty to any company under this act or any previous company law during last 5 years. This person, your promoters, has not been found guilty. Has not been found guilty. He has not done anything wrong. So you might have known about the Kingfisher Airlines fraud that was done by Vijay Mallya. Now Vijay Mallya has done something wrong. It has been a lot many years since that has passed. But if he has been found guilty in the recent years, suppose he was found guilty in 2019 and today is 2024. He was found guilty on suppose 1st of August 2019. So still 5 years have not passed. So this man cannot become a subscriber of memorandum. And that all the documents filed with the registrar for registration of the company contain information that is correct and complete and true to the best of his knowledge and belief. And they should also promise that whatever information, whatever documents we have filed with registrar of companies are correct and true. Okay. So these three things they may ask you as a question. A declaration, what type of declaration is required from subscribers of memorandum, subscribers to memorandum. Okay. Now, address of correspondence till its registered office is established. The address of correspondence also has to be informed to the ROC. Particulars, names including surnames or family names, residential address, nationality of every subscriber to the memorandum, along with proof of identity. And in case of a subscriber being a body corporate, such particulars may be described. So you have to give all the details of the people who are your subscribers, their name, their if they have a specific surname that is to be mentioned, a family name if they have to mention that also. Residential address, like instead of surname, some people have the family name, so they use that. Residential address is to be given. Is he a resident or not, Indian or a foreigner? That is also to be mentioned here. Particulars, names including surnames or family names, directors of the persons mentioned in the articles as subscribers of memorandum. So all the details as mentioned in articles as the subscribers of memorandum should also be provided. This was in the memorandum. Every subscriber's details are given, and the name of the persons mentioned in articles and such other proof, including proof of identity as may be prescribed. So their identity proofs also have to be given. So these points can be combined. You can write one point only, like for every subscriber, you have to give the details. The particulars of the interest of the persons mentioned in the articles as the first directors of the company in other firms or bodies corporate along with their consent to act as directors of the company in such a form and manner as may be prescribed. Now, if ABC Limited is formed, ABC Limited, okay, 1 second, right now, ABC Limited is formed and the directors are D, E, and F. So D and E are already directors of DE Limited, right? They are already directors of DE Limited. So if any of the people are directors of other companies also, that details, name of the company where they are already directors is to be given. Okay. Are these points clear to you people?
Yes, ma'am.
Particulars provided in this provision shall be of the individual subscriber and not the professional engaged in incorporation of company. CA, lawyer, CS, CMA, they are not the subscribers. Their details are not to be given, right? So people who are actually subscribing, who are going to pay the money, their details are to be given. Issue of certificate of incorporation of registration. Registrar on the basis of documents and information filed shall register all the documents and information in the register and issue a certificate of incorporation in the prescribed form to the effect that the proposed company is incorporated in India. So registrar will see that all the documents are correct and then he will issue a certificate of incorporation. Okay. And they have a specific format for the certification of incorporation that they will use. On and from the date mentioned in the certificate of incorporation, registrar shall allot the company a corporate identification number, CIN number, corporate identification number, shortcut is CIN number, which shall be distinct identity for the firm and which shall also be included in the certificate. So they will give a specific CIN number to them, and from that only you can like access the website of MCA where you can do things, and that will be an identity number. Like PAN as an identity number, and they also have the SIN as an identity number. Now, is the Chrome website open to you, like available to you for seeing? Or you see only the PDF?
The PDF.
Okay, 1 second. Here, see, this is the MCA website. And when I want to know about any company, I will have to see with the identification number, I'll have to check. Now, here you see LLP e-filing, company e-filing. Here, company files all the data. Okay, MCA login if I want to do. So MCA login will ask me username, password. Here you can access the website of MCA. If I go for MCA services, they will ask you to find the company. AC. Okay, 1 second. I guess they have changed. Hmm. If I want annual reports, there they have changed it. Company LLP information. Now here they'll give you detail of all the companies and LLPs that have been registered over in 2024 April. So you can see they give a specific CIN number. This is LLPN number. That means they are given the LLPN identification number. If I go for Indian companies, we can see CIN number. So this is a CIN number that is given as a specific identity. Okay, you get the information that which type of companies are formed, what is the name of the company, private limited, one person companies, public limited, everything will be maintained in the website. So that is why more people do not comply with companies, because all their personal information is leaked. So you can see in India, in a month, how many Indian companies have opened up, right? So it's nearly 15,973 Indian companies have opened up in just 1 month, April 2020. Okay, and these are mostly non-government companies which have opened up. Okay, the Excel is not visible to you, right? See, this is the CIN number. This is how a CIN number is given. And this is the data of the companies which have opened up in April, right? So nearly around 15,973 companies have opened up in April month only in this financial year, right? Then you have the LLP companies data, which LLPs have opened up, that data you can have. Foreign companies data, how many foreign companies have opened up in India in 1 month, and they get a FCIN. Foreign companies get an FCIN, LLPs get a LLPIN, and companies get a CIN. Okay. Near what was the last thing that you people heard? Am I audible to you
Like,
people? Yeah. You saw the CIN number, etc.
yes, ma'am.
Okay. So that is how a CIN number is allotted. Maintenance of copies of all documents and information. Company shall maintain and preserve at its registered office copies of all documents and information as originally filed till its dissolution under this act. If you have once filed the company, if you have once filed for the company registration, whatever documents you filed on the first day of company registration, when you got the company registered, these documents you have to preserve till the dissolution of the firm. You can't say that the documents are not there. Keep a scanned copy of it or any form, but those documents are must. You have to maintain those documents. Furnishing of false or incorrect information or suppression of material fact at the time of incorporation. If a person furnishes any false or incorrect particulars of any information or suppresses any material information which is aware in any of the documents filed with registrar in relation to registration of companies, he shall be liable for action for fraud under section 447. If you do not give proper details, you give false details or incorrect details, or you try to suppress any material facts, you are going to trade in the guns, right? You are going to buy and sell the guns, and you don't inform the companies that we are going to do this activity. You are suppressing a material information. Material means important information. So if you are doing so, the registrar can file a complaint against you and you shall be liable for fraud. Company already incorporated by furnishing any false or incorrect information or representation or suppressing any material fact. That is, you get to know after incorporation that something wrong was given by the companies. ROC gets to know that we had given something wrong information. Where at any time after the incorporation of a company, it is proved that company has got incorporated by furnishing any false or incorrect information or representation or by suppressing any material fact or information in any of the documents or declaration filed or made for incorporation or by any fraudulent action, the promoters, persons named as first directors of company, and the persons making declaration under this section shall each be liable for the fraud. Now, who all will be liable? People who are the promoters, who are the people that were the first directors of the company. Even if the fraud comes to the picture after 2 years and that directors are not the directors anymore, still the first directors will be held liable. And the person who give the declaration, if CA has given the declaration like this is the facts and this is company which is going to be incorporated, that CA will also be punished. He will also be involved in the fraud. Are these 2 points clear?
Yes, ma'am.
Order of the tribunal. where a company has got incorporated by furnishing false or incorrect information or representation or suppressing any material fact information in any of the document or declaration filed or made for incorporating such company by any fraudulent action, tribunal may, on application made to it, on being satisfied that the situation so warrants, pass such orders as it may think fit for regulation of the management of the company, including changes, if any, in its memorandum and articles in public interest or in the interest of the company and its members and creditors. Sorry. Or direct the liability of the members shall be unlimited. Direct removal of the name of the company from registrar of companies. Pass an order for winding up of companies. Pass such orders as it may deem fit. If the tribunal, so National Company Law Tribunal (NCLT) is set up to protect the companies and the other people who are being affected by the company's fraudulent activities. If companies get to know that someone has done fraud and by fraud they have got the registration, so what the tribunal will do? Tribunal may, on application made to it, if registrar of company makes an application to it, tribunal will pass such orders as it may think fit, as it thinks necessary for regulation of the management of the company, including changes. It will say management has to change. We need a new management or change in the memorandum and articles in public interest. They may ask change the memorandum. If you earlier said that we are going to sell only the footwear and now you are getting into clothing business and you are getting into medicine business also, you need to change the memorandum of association. So now these words need to be included, which is in the public interest. Or else what company will think, if suppose Bata starts selling medicines, Bata starts selling medicine. Bata is the company of footwear. If it starts selling medicines, people will not understand. They will think a footwear brand is selling the medicine. That is something fishy. But if you want people to gain the interest in the public interest, they will inform that in their memorandum and articles of association, they will make the amendment, make the correction that we are also selling medicine, or in the interest of company, or the company will benefit out of it and the members or creditors will benefit out of it. This is first thing that they will say, like change the management or change the memorandum or articles of association. Then they can also direct that liability of members will be unlimited. The members have to give unlimited amount. Even if something goes wrong in the company, you have to pay the money from your personal assets. Direct removal of the name of company, or order shall be passed that you have to remove the name of this company from register of companies. This company is not going to be in existence. Pass an order for winding of the company. They will say wind up the company. They can pass that order also. Pass such orders as it may deem fit. Any order they want someone to go to jail and they want someone to punish, like they want to punish someone, any liability they want to put, penalty they want to put, they can put all these things. Provided that before making an order, company shall be given a reasonable opportunity of being heard in this matter. In law, you have to remember, whenever a fraud is happening or any of the situation, courts are being involved, they will always give you a reasonable opportunity of being heard. They will always give you a chance to explain yourself. The tribunal shall take into consideration the transactions entered into by the company. Tribunal will consider all the transactions company has done, including the obligations, if any, contracted or payment of any liability. If a company has to pay the bank loan of rupees 2 crore and now the tribunal has found that they have done something fraud, now they ask you to wind up company. So first what they will say, pay this loan, 2 crore loan you have to pay first and then only you can wind up. Okay. Are these points clear? Order of tribunal.
Yes, ma'am.
Okay, let's go ahead. Simplified pro forma. for incorporating company electronically. So I told you, like, companies can get incorporated electronically also. Ministry of Corporate Affairs has taken various initiatives for ease of business in a step towards easing setup of businesses. MCA has simplified the process of filing of forms or incorporations of company to simplified pro forma for incorporating company electronically. You can also form the company electronically. Let me share that. Now you can see this is the MCA website, Ministry of Corporate Affairs. My application, you can go, and here you can try to fill an application to MCA website. Okay, you can get the registration, user login registration you can do. If your first time, you can get it registered, then you have to file all the documents. All the details will be filed over here. What is the user role you have to specify? If I am a registered user, then I will choose a role over here. Income tax PAN number I have to put of company. Personal detail, contact details, all these things are to be specified over here. Okay. Then you can also see company e-filing, incorporation services, what they are mentioning over here. You can get the incorporation done over here. First one is run. So here you will have to first create your ID, and then you can fill the form and incorporate yourself on the company's website. Okay. Now, effect of registration. Section 9 of the Companies Act 2013 provides for the effect of registration of the company. Section 9 says how the company will be effective. According to Section 9, from the date of incorporation mentioned in the certificate of incorporation, subscribers of memorandum and all persons who may from time to time become members of the company from the date of incorporation. From this date, all the members who are there will be, all the subscribers of the memorandum will become members of the company. Shall be a body corporate by the name contained in the memorandum. Company will become a body corporate by the name that is given in the memorandum. Such a registered company shall be capable of exercising all functions of an incorporated company under this act. So you will now start acting as a company under this act, and having perpetual succession with power to acquire, hold and dispose of property, both movable and immovable, tangible and intangible, to contract and sue and be sued by the said name. Now you can use this name for buying any property or selling any property. You can buy movable, immovable property, any tangible or intangible property, can enter into a contract and can sue other people, or other people can sue the company in the said name, whatever name they have selected. From the date of incorporation mentioned in the certificate, company becomes a legal person separate from its incorporators. It becomes a legal separate entity from the people who have incorporated the company, who have formed the company. And there comes into existence a binding contract between a company and its members, as evidenced by the memorandum and articles of association. Now, memorandum of articles and memorandum of association and articles of association is acting as a contract between whom? The company and the members. It has perpetual existence until it is dissolved by liquidation or struck out of the register. It will continue to exist. Company will continue to exist till its name is taken out from the register or it has gone into liquidation. A shareholder who buys shares does not buy any interest in the property of the company, but in certain cases, a writ petition will be maintainable by company or its shareholders. A shareholder who buys share does not buy any interest in the property. He will not get any income of the property. He will just buy share of the company. He will just buy a share in the capital of the company. But you can't say this land and building is mine. You took the shares of Tata Motors. You can't go and say this office is mine. Tata Motors office is mine. Because you just have bought a share. You don't have the right in the interest in the property of the company. A legal personality emerges from the moment of registration of a company and from the moment the person subscribing to the memorandum of association and other persons joining as members are regarded as a body corporate or corporation in aggregate, and the legal person begins to function as an entity. A company on registration acquires a separate existence and the law recognizes it as legal person separate and distinct from its members. Now, a legal personality emerges the moment of registration happens. When the registration happens, your company will become a separate legal entity. And from that moment, persons subscribing to memorandum of association and other people who are joining as members are regarded as body corporate or corporation in aggregate. They all will be said as, okay, you all become a body corporate today. And the legal person begins to function as an entity. And your company will start now being a legal person. A company on registration acquires a separate existence and the law recognizes it as legal person separate and distinct from its members. So here your company will be a separate entity and your members will be a separate entity. Is this point clear?
Yes, ma'am.
It may be noted that under the provisions of this act, a company may purchase shares of another company and thus become a controlling company. Here, a company can purchase shares of another company and thus it can become a controlling company, a holding company. However, merely because a company purchases all shares of another company, it will not serve as means of putting an to corporate character of another company. And each company is a separate juristic entity. So if Mr. A, sorry, not Mr. A over here, A Limited buys 60%, or you could say 100%. Let's take it as 100%. Buys 100% stake or shares of B Limited, then B Limited still will be a company. Still will be a company and it will still have a separate legal character. Separate legal entity. It will still remain a separate legal entity. You can't say A Limited is a separate legal entity and B is just a subsidiary. A subsidiary will also become a separate legal entity. It will still hold the title of being separate legal entity. The law recognizes such a company as juristic person, separate and distinct from its members. B Limited will still remain separate. Mere fact that the entire share capital has been contributed by central government and all its shares are held by President of India and other officers of central government does not make any difference in the position of a registered company, and it does not make a company an agent either of President or central government. Instead of A Limited, if I would have told you that this company was bought by the central government, right? The president bought this company. This was bought by central government buys the stake of B Limited. Even though if central government buys the stake of this entity, B Limited will still continue to be a separate legal entity. It will not be called as agent of the central government or the president. Okay. Even though it is acting or like it is going to be run by the central government or the president, still you can't say this entity is the agent of president or the central government. Okay. Effect of memorandum and articles. As per section 10 of the Companies Act 2013, where the memorandum and articles when registered shall bind the company and the members thereof to the same extent as if they respectively had been signed by the company and each member, and an agreement to observe all the provisions of memorandum and of the articles, all monies payable by any member to the company under the memorandum or articles shall be a debt due from him to the company. Now, what they have said, as per section number 10 of Companies Act, where memorandum and articles when registered, when they get registered, they shall be binding on the company and the members have to pay the amount, have signed the document. So an agreement has been made between members and the company, right? And they have to follow all the provisions written in the memorandum and articles of association. So A, B, and C become the members of ABCD Limited. So these three people have to follow all the provisions written in your MOA, Memorandum of Association, and AOA, Articles of Association. Okay. And all that money that is payable by these members to the company will be the debt of the company. Company has given you some loan that you have to repay. Okay, it is not fact that company has given you loan, but in the agreement it is written you have to pay, so that becomes a kind of loan. Till here, is it clear? Registration of the company.
Yes, ma'am.
Yes, ma'am.
Let's go ahead. Classification of capital. Now, the term capital has a variety of meanings. It means one thing to economists, another to accountants, and still another to businessmen and lawyers. So three people have three different ideas about capital. Economists have a different idea. Your accountants, chartered accountants, or your regular accountants, CSCA, all have the different idea, CMA. And your businessmen think as a different concept of capital. Along with businessmen, there comes lawyers too. In relation to a company limited by shares, the word capital means share capital. If some company is limited by shares, you have to pay the amount to get the share of the company. So that is your share capital. That is capital or figure in terms of so many rupees divided into shares of a fixed amount. So if we say that the capital of a company is 2 crore rupees, right? If I say capital is 2 crore, so it will be divided into small share of amount. Suppose rupees 100 per share, right? Rupees 100 per share. So if I'm taking rupees 100 per share, so it will issue 2 lakh shares. 2 lakh shares. 2 lakh people can buy it, or 10 people are buying the shares of this. So 20,000 each person is buying. So that is how share capital works. Entire amount split, divided into small divisions or into small parts of fixed amount. Okay, this share amount, price of the share will be fixed. In other words, the contributions of persons to the common stock of company, means to the common amount of company, form the capital of the company. The proportion of the capital to which each member is entitled is his share. As I told you, 10 people have got 20,000 each of share. So that is their share in the company. Okay, all of them have the equal share. A share is not a sum of money, it is rather an interest measured by a sum of money and made up of various rights contained in the contract. It is not a sum of money that you hold or that you give to the company. It is somewhat interest that you are giving in the company, rights that you are taking off the company. For our technical, for the theoretical knowledge, it is important, like you see that it is not a sum of money, but in actual you pay some money to get the share of the company. In the domain of company law, the term capital is used in the following senses. So capital will be used in different senses. Is this first classification of capital like name clear to you?
Yes, ma'am. Clear.
Okay. Now, first is nominal or authorized or registered capital. Now, this capital, whatever you are saying, will be written in your memorandum of association. That memorandum that you sign with the ROC, in that you will be mentioning that maximum capital that we will be taking in the entire lifetime of a company is of rupees 20 crore, 30 crore. You can write it that way. Okay. This form of capital has been defined in section 2(8) of the Companies Act 2013. Authorized capital or nominal capital means such capital as is authorized by the memorandum of company, which is written in the memorandum of the company, to be the maximum amount of share capital of the company. This is the maximum amount a company will be paying, like a company will be raising from the people, or company will be taking from other people to form the company. Thus, it is the sum stated in the memorandum as the capital of the company with which it is to be registered, being the nominal or the maximum amount which is authorized to raise by issuing shares and upon which it pays the stamp duty. It is usually fixed at the amount which is estimated the company will need, including the working capital and reserve capital, if any. Now, this is the maximum amount they can say. Suppose they say we will maximum take our authorized capital as 20 crore. So during the lifetime of ABC Limited, if it has written in MOA that our authorized capital is rupees 20 crore, they can raise in the entire lifetime. 2015 it is registered, 2017 it raises, 2018 it raises, then 2020 it raises, 2024. So if the company is going to still continue for 10 more years, you can just raise till 2 crore. Now you raised 1 crore, 1 crore again, 1 crore again, and here 10 crore. Then you have 13 crores already used, now 2 crore again. So you are left with 5 crore that you can raise in the entire life of the company. Okay, this is the maximum amount of capital you can have in the company. It is usually a fixed amount which is estimated that company will need. For the entire life, you will estimate an amount that this much amount our company will need in the entire life, including the working capital and reserve capital. Your reserve capital, capital that you set apart for your like buying a building or buying some new trade center, etc., or buying some plant and machinery, that reserve capital will also be included over here in this 20 crore. Okay. Is nominal or authorized capital clear to you people?
Yes, ma'am.
Yes, ma'am.
Issued capital. Now, out of 20 crore, I told you that we are going to take first 1 crore. So this capital is issued, which I have asked people to pay. This is again your issued capital, right? Section 250 of Companies Act 2013 defines issued capital, which means such capital as the company issues from time to time for subscription. It says now pay 1 crore, people will pay 1 crore. Again, they will say pay 1 crore, people will pay 1 crore. It is that part of authorized capital which is offered by company for subscription and includes the shares allotted for consideration other than cash. Other than cash also you can ask the people to buy the shares. Now some are your employees, right? Now some of them are your employees. This will be asked to you like this, you will get to know in your inter or finals, but I'm just giving you an idea. Now employees, they are going to be given salary of 10 lakh. 5 employees are there, they will be given salary of 10 lakh each, but they say 10 lakh is very much less. So company will say we will give you shares. We will give you shares of 2 lakh each. Each person will get 2 lakh shares. So this is your shares given. But are you giving them any cash or they are paying you any cash money? No, these employees are getting salary. You are going to pay them. They are not going to give you any money for this share. These 2 lakh that you give them as share is a consideration other than the cash. For that, you are giving the shares. Schedule 3 of the Companies Act 2013 makes it obligatory for a company to disclose its issued capital and in the balance sheet. So in the balance sheet of the company, you have to mention what is your issued capital. Is issued capital clear to you people?
Yes, ma'am.
Okay. Let's go ahead and see subscribed capital. Section 286 of the Companies Act 2013 defines subscribed capital as such as part of the capital which is for the time being subscribed by the members. It is the nominal amount of shares taken up by the public where any notice, advertisement or other official communication or any business letter, billhead or paper letter of a company states the authorized capital, then the subscribed and paid up capital must also be stated in equal conspicuous characters. A default in this regard will make the company and every officer who is in default liable to pay penalty extending of 10,000 and 5,000 respectively. Now, you have to let the company know how much is your total subscribed capital. 20 crore is your authorized capital. Out of this, you issued how much capital? You issued around 2 crore of capital till date. From this, how many people have subscribed? How many people have got your shares? If only 1.8 crore people, share capital has been subscribed. So you have to mention this. And if you do not mention this, if the company defaults in mentioning the subscribed capital, company has to pay fine of 10,000, and the proper officer who fails to show this amount of subscribed capital will have to pay fine of 5,000 rupees. Okay, is subscribed capital clear to you people?
Yes, ma'am.
You issue an amount, but people do not subscribe to the entire amount. Or if people subscribe to more amount, but you give less shares, like they come and give you the money of 4 CR, but you can only give 2 crore people the shares. If your share is for rupees 1, you can only give 2 crore people the shares. So this will be your subscribed capital. How many people come and give you the money? How many people can go and subscribe to you? We see the subscribers on YouTube, similar manner. How many people come and see your videos, like your videos, subscribe to your channel? That is your subscribe capital. Then called up capital. Company has defined, 215 of the companies have defined called up capital as such part of the capital which has been called for payment. It is the normal total amount called up on shares issued. Now you issued share capital of 2 crore and you said don't pay entire 2 crore, only pay 1.2 crore today, and remaining 0.8 crore we will ask you in November month. This is to be paid in May and this will be asked in November 2024. Right? So this 1.2 crore that you're calling people to pay, that you're telling people to pay, is called as called up capital. If in November I will be saying them to pay 0.8 crore, that will become my called up capital. Then you have your paid up capital. It is the total amount paid or credited as paid up on the shares issued. It is equal to called up capital less calls in arrears. Now, I told that in the financial year, May I called up 1.2 crore. Then again in November, I called up 0.8 crore. But how many people paid out of 2 crore? Only 1.9 crore paid. 0.10 crore people did not pay the amount, right? So I will say my paid up capital is 1.9 crore because only this much people have paid me the money. Called up capital less calls in arrears. I called up 1.2 plus 0.8 minus this is arrears. Arrears means people who have defaulted, who have not paid the money. Okay. Is subscribed capital, called up capital and paid up capital clear to you people?
Yes, ma'am.
Okay. So this is very important for you people to remember types of capital. They can ask you a direct question for it. Now, what are shares? We will see what is share. Share means a part of something. We say that, can you share this thing with me? You want a piece of it, a part of that with you. Share a copy of this document with me. So you want that copy, like similar document. Nature of shares. Section 284 of the Companies defines the term share, which means a share in the share capital of a company and includes stock. So whatever a company has, a share capital and a stock of the company, in this you ask for a share. Share in the share capital is called as a share of the company. A share thus represents such proportion of the interest of shareholders as the amount paid upon thereon bears the total capital payable to the company. So whatever is the amount you are asking for the share, that is your amount payable to the company. It is the measure of the interest in the company's assets to which a person holding a share is entitled. Now, if I ask ABC Limited to give me 5 shares and one share's price is rupees 1,000. So 5,000 will be my interest in the company. If I pay 5,000 rupees to them, that is the amount payable to the company and that is the amount of interest I have in company's asset. I can get 5,000 rupees from the company because that is how much I paid to the company. That is only the extent of assets of the companies. Like if a company has a laptop and I am a shareholder and that laptop is worth 35,000. I can only take 5,000 out of it. Whenever the laptop will be sold on winding up, when the company will close, that time out of the sale of laptop, they can pay me 5,000 only because 5,000 is the amount I paid to the company. Okay, is it clear?
Yes, ma'am.
Okay. Share is an interest in the company, the benefit you want in the company, the motive of yours investing in the company. Farewell justice in Borland Trustees versus Steel Boards and Company Limited observed that a share is not a sum of money, but it is an interest measured by a sum of money and made of various rights contained in the contract, including the right to a sum of money or a more or less amount. Now, this 5,000 that I'm paying is going to give me rights of the company. If the total capital is only 10,000 of the company and I have 5,000 rupees, right? If I am the owner of 5,000 rupees, that means now I have got the right of taking the decisions of the company because I have 50% stake in the company. 50% is mine. So I've got a right. If some person has, suppose I have only 4,000, the other person has 6,000. So he will become the director of the company. He can have all the rights of the company. He can run the company as he wants because major portion is there. So rights are transferred when you subscribe to a share or when you buy a share. You get the rights in the company. That is what is said by farewell justice. You should note that the shareholders are not in the eyes of law part owners of the undertaking. Shareholders are not in the eyes of law part owners. You are not the part owners of the undertaking. The undertaking is somewhat different from the totality of shareholders. Rights and obligations attaching to a share are those prescribed by the memorandum and the articles of company. In the articles of the company and memorandum of company, if they have written, these are the rights and obligations of shareholders. That much right and obligation only the shareholders have. It must, however, be remembered that shareholder has not only contractual right against the company, but also has certain other rights which occur to him according to provisions of the Companies Act. You have the rights to get into contract with company. You can ask the company to pay 5,000 anytime you want because you have paid the money. Now you will say, I want to sell my share, give me back the money. Now, your share capital will be divided in these types. Share capital, it will be equity share capital or preference share capital. Now, preference share capital, I'll give you a limited idea. They have given in detail. This will be paid first. They will get a preference. They will get compulsory dividend or interest. Dividend or interest. Your equity share people, they will not get dividend or interest compulsory. Not compulsory dividend. Dividend is not compulsory. With uniform voting rights and with differential voting rights. We will be seeing this. Some will have some uniform voting rights. Everyone has same voting rights. In the differential voting rights, some people who are having the major stake will have different rights and people who have less share will have different rights. Now, shares are movable property. You can transfer the shares anytime you want in the public company. In the private company, there are some restrictions. According to Section 44 of Companies Act, shares or debentures or other interest of a member in a company shall be movable property, transferable in the manner provided by the articles. If in the articles of association it is written, you can sell the shares after 4 days, you can start selling the shares after 4 days. Shares shall be numbered. Every share is in a company having a share capital shall be distinguished by its distinctive number. This implies that every share shall be numbered. However, this shall not apply to a share held by a person whose name is entered as holder of beneficial interest in such share in the records of a depository. We'll be seeing that in further. Now, every person, whatsoever share you buy, that share will have a unique number given to that share. And if I sell a share to Gopika, so Gopika will get that serial numbered share. Okay. However, this shall not apply to be held by a person whose name is entered as holder of beneficial interest. The people who are having beneficiary interest, who are the subscribers, promoters of the company, they will not have the shares as numbered. Okay, clear everyone? Should I go ahead?
Yes, ma'am.
Okay. Kinds of share capital, as we already saw, equity share capital and preference share capital. Now, Section 43 of the Companies Act 2013 provides the kinds of share capital. According to provision, share capital of a company limited by shares shall be of two kinds, namely equity share capital, with voting rights or with differential rights as to dividend, voting or otherwise in accordance with prescribed rules. So some equity share capital come with the voting rights. Some will not be given voting rights. They may be just given dividend, or some will be given with dividend and voting rights, or anything otherwise. Let's see an example, you'll understand. It is to be noted that Tata Motors in 2008 introduced equity shares in differential voting rights called A equity shares in its right issue. In this issue, every 10 A equity shares carried only one voting right but would get 5 percentage points more dividend than that declared on each of the ordinary shares. Since A equity share did not carry similar voting rights, it was being traded at discount to other common. Now, here what has happened in 2008, Tata Motors said, we are issuing A type of equity shares. And if you are having A type of equity shares, 10 A type of equity shares, then you get one voting right. You will get the power to vote as one person, like it will be counted as one vote. And but would get 5 percentage points more dividend. Now, if I have A quality, A equity share, and Gopika has B equity share. So if Gopika is going to be paid 50 rupees dividend, I will be paid plus 5 points. 50 plus 5 points, that will be a 55 rupees I will be paid, and Gopika will be paid rupees 50. And the voting rights are also not similar. Since A equity share did not carry similar voting rights and it was being traded at discount to other common shares having full voting, other companies which have issued equity shares with differential voting rights, popularly called as DVRs, are Future Retail, Jain Irrigation, among others. So these are different people who took the idea of attracting people. They started giving the voting rights, or they started giving the differential voting right shares in the company, in the market. This were Future Retail and Jain Irrigation. Seeing Tata Motors doing this, Jain Irrigation and Future Retail also started giving differential voting right shares. Okay. Is equity capital clear to you people?
Yes, ma'am.
Then we have your preferential share capital. Preferential share capital is kind of a loan that the companies give. In India, mostly companies do not offer preferential share capital because it becomes compulsory to like pay some amount as interest, etc. However, this act shall not affect right of preference shareholders who are entitled to participate in the proceeds of winding up before the commencement of this act. So if any preference shareholders are having their shares before the commencement of this act, before 2013's act, they will not be considered over here. According to explanation to section 43, equity share capital with reference to any company listed by share means all share capital which is not preference share capital. Preference share capital is different and equity is different. So capital which is not preference share, that is your equity, which will not be given the preference, which will not given the priority. When everyone is going to be paid, these people will not be given the priority. Equity shareholders are the last who are paid. They are the last people paid on winding up. And if some amount is remaining after winding up, then only they are paid, or else they will get no money also. Let's see preference share capital. With reference to any company limited by shares means that part of the issued share capital of the company which carries or would carry a preferential right with respect to payment of dividend. They will be given a preferential right. They will be paid dividend. Like either the company makes profit or not, they will be given a dividend. Either as a fixed amount or an amount calculated at fixed rate. They will be given a fixed amount. Rupees 10 per share will be the dividend. Or they can give 10% of the share price, which may either be free or subject to income tax. Now, this may be taxed in the income tax or it can be free from income tax. That we will be seeing in our finals and inters. Okay, so your preference share capital is compulsory payment. It is just like taking a loan. On loan, you have to pay the interest. Suppose 11% you pay the interest. Similar way, if you are taking preference share capital, you have to pay the preferential dividend. Preferential dividend. Okay. So usually in India, people don't go for preference share capital. The companies don't go for preference share capital. Repayment in case of a winding up or repayment of capital of the amount of share capital paid up or deemed to have been paid up, whether or not there is a preferential right on the payment of any fixed premium or premium on fixed scale specified in the memorandum or articles of company. If they have been said that you will be repaid at 110 rupees, if the share is of 100, when the company will wind up, you will be repaid at 110. Even if the company is not having enough money, still this 110 is going to be repaid to the preferential share capitals because they have a right over the repayment. They will be given the advantage over everyone in the preferential in the winding up of company. Okay, is preference share capital clear to you people?
Yes, ma'am.
Private company, section number 43 will not apply. Preferential capital will not be in the picture of private companies. Okay. Now, memorandum of association. Okay, you need any break or something, please tell me, because we have been learning 3 concepts we have learned for now. If you want 5 minutes break or something, tell me, then we can review.
Break.
5 minutes is okay? Or 10? 5 minutes or 10 minutes? Okay, we'll resume at 8:25. Memorandum of association. The memorandum of association of a company is in fact its charter. Charter, that is a like what you call it, a way how it is going to behave, the guidelines it how the company is going to behave. It defines its constitution and scope of powers of the company with which it has been established under the act. It will tell what are the powers of the company. It will say how the company is constituted, what is the share capital, how directors will be appointed. Everything is written in your MOA and AOA, Memorandum of Association and Articles of Association. It is very foundation on which the whole edifice of the company is built. The entire working functioning of the company is built on Memorandum of Association. Object of registering a memorandum of association. Why do we get this registered? Because it is formed and therefore identifies possible scope of its operation beyond which its actions cannot go. I explained you that if you are dealing in footwear business, you can't go and deal with in your medicine business. That is not written in the scope of your business. It is not written in the MOA. Objective of company does not include that Bata will now start selling medicines. Bata is going to sell footwear, that is written. So it can do. If it wants to sell medicine, this words selling medicine, this is our new task, has to be written in the MOA. It has to be mentioned in the memorandum of association. It enables shareholders, creditors, and all those who deal with company to know its powers and what activities it can engage in. Everyone will get to know what are the things that a company will be doing. I will just see quickly if I can get a memorandum of association for you. Okay, Reliance is not keen. Right. 1 second, I will share this with you people. This is MOA and AOA of Reliance. So here your MOA starts on page number 3. Let's directly jump to MOA. These are the certificates that Reliance has. You can see these certificates. Let me show you. This is the company's certificate of registration of order of confirming transfer of registered office from one state to another. First, their registered office was on different place. Now they shifted to another. Changing it from the state of Karnataka to Maharashtra. Earlier it was in Karnataka. Now it came to Maharashtra. Bombay. So this one is registered one. Then we have your certificate of registration of the order of company law confirming transfer of registered office from one state to another. Again, the same type of thing that they have mentioned over here. In 1977, they changed their office. Then this one is your fresh certificate of incorporation consequent of change of name. Now they have changed the name. So that is also mentioned over here. Certificate of commencement of business. When it commenced, they got this certificate registered. Certificate of incorporation is given. Bangalore, Karnataka. Now your MOA starts. Main objectives to be pursued on incorporation of the company. To carry on the business. Okay, let me just zoom it a little for you people. To carry on the business of manufacturer, dealers, agent, factors, importers, exporters, merchants, and financiers of all kind of man-made fiber and man-made fiber yarns of all kinds, man-made fiber cords or all kind of kinds, and man-made fiber fabrics of all kinds, mixed with or without mixing material like woolen, cotton, metallic, or any other fibers of vegetable, mineral, or animal origin, manufacturing such man-made fibers and man-made fiber products. So you see how detailed they have mentioned over here. Everything that you're going to do, you have to mention in your MOA. Now it is doing different businesses. That was for cotton, like that was for cloths. Now this is petrochemicals. For every detail of petrochemicals they have given. Then carrying on selling, business, exchange, converting, this is twisting or other handling, dealing with advising users in the proper of cotton yarn. So this is again your cloth thing that they have mentioned. To manufacture spare parts, this is a separate thing. Turnkey basis outlets, whatever different types of projects they are going to set up, stores, markets, etc., malls, shopping outlets, that is written. Then facilities on payment, collect, deposit. This is your bank related things that they are going to do. Geo payments you might have heard. So what all things you are going to do, you have to mention over here. To provide globally managed data network. So again, you can say here the cloud services, your IT services, whatever they are going to provide, everything is to be mentioned in detail in your MOA. Then objects incidental, what they have written, the objects incidental or ancillary to the attainment of main objective. These are our main objectives. For this, we need supporting objectives. For this, we will be getting into contracts with Indian and foreign individuals. We will be taking loans. We will be taking technical financial help also. Then we will be maintaining some agencies. Jio has agencies. Reliance Smart has agencies. Reliance Digital has agencies. That adopt a means of making known business activities, that also you have to give them. We will be issuing books, pamphlets, circulars, price list, etc. Then purchase or otherwise of Burwett de-invention licenses, whatever licenses they are going to take, they have to mention that. Then research and development thing we are going to do. For this, we will be spending our money. Right? For licenses, buy and per sale, that also you have to mention. We will be entering into partnership. We will be doing different types of business like joint venture, cooperation businesses, that you will have to mention. Right? So have you got a little idea of MOA?
Yes, ma'am.
Yes,
So
ma'am.
more of the objectives in MOA, everything that you are going to do, you have to write in detail. If you are going to enter into some business of just clothing, you want to sell on Ajio. Reliance has a brand Ajio. So if it is going to sell on Ajio, the e-commerce website also, it has to give every detail. What are you going to do? What all things will be there? Your own brand will be there, or other people's brand also you're going to sell. What is the policies, etc., that you're going to make? That also you have to write there, that if buy and return exchange policies will also be applicable. That entire description is to be written. We are going to give them technical support. We are going to give them shipping support, delivery support. All this is to be written in your MOA. So this was the MOA that contained all the things. Then here end notes are given. Authorized share capital is 3 crore 75 lakhs at the time of incorporation. And it was modified by passing requisite resolutions at the meeting. So whenever you want to make a change in the company's any document, you have to pass a resolution. Then they have given what is the modification that they have done. Total authorized capital 3 crore 75 lakh to it has now come around 15,000 crores. Okay. So you can see 3.75 crore of capital became 15,000 crore on September 1, 2017. Now, here the details are given of these are the names of subscribers. MD Shivanjappa for Mysore State Industrial, Mysore Industrial Corporation. Then your Shivanjappa Devappa, TR Satish Chandran Ramya. Then Shishidhari Sitaramya, Ramesh Pai. All these details are mentioned over here. Who all have subscribed to the share capital, all these details will be given. Okay, then starts your article of association. We'll come back to this again when we study articles of association. Okay, I hope this was clear to you people. MOA, how I gave you an idea about it. Okay. Now, so it is available for everyone. Now, I want to read the Reliance MOA. I just got to read it. So, creditors, the people who are investing, shareholders, etc., have the access to the MOA so that they know what company is actually going to do. And if company is not engaging in those activities and doing something different and it is not mentioned in MOA, we can file a case against it. And if it is doing some fraud, etc., people can file the case against it. A memorandum is a public document. It is available to the public under Section 399 of Companies Act 2013. Consequently, every person entering into a contract with the company is presumed to have the knowledge of conditions contained thereto. So, if you are entering into any contract with Reliance, you have read the MOA and AOA. It is considered. It is deemed that you have read it because it is freely available. You should read MOA and then only subscribe to the shares of the company. Then only you should buy the shares. But no one actually does this in practical life. It is just considered that you have read the MOA. Shareholders must know the purpose for which his money can be used by the company and what risk he is taking in by making the investment. When I'm investing the shares, I should know where my money will be used. That's why I should be aware of MOA. Okay? Clear? Is this first point clear?
Yes, ma'am.
Okay, let's go ahead. Let's see the next one. A company cannot depart from provisions contained in the MOA. You can't change or you can't do anything different that you have mentioned in MOA. However, imperative may be the necessity for the departure. There might be some necessity in the departure that you may do something different than that is mentioned in MOA. It cannot enter into a contract or engage in any trade or business which is beyond the power confessed by it in the memorandum. You can't do anything that is not written in your memorandum. That is why whenever the memorandum of association is made, companies write every detail, small detail. You are going to mix the fabric, you have to write you are mixing it. You are going to dye the fabric, you are going to paint or color the fabric. Every detail you have to mention it. If it does so, it would be ultra vires the company and void. Ultra vires means you are breaking the provisions that you have made. You are doing against the provisions that you have made. Okay. As per Section 4, memorandum of a company shall be drawn up in such form as is given in tables A, B, C, D, and E in Schedule 1 of the Companies Act 2013. So your MOA will be distributed in 5 tables. Table A, B, C, D, and E. A table is form of Memorandum of Association of Company limited by shares. Limited by shares will take MOA 1, like table number 1. Is a form of memorandum of association of company limited by guarantee and not having share capital. These will be filling table of table number B, who the guarantee ones, whose company is limited by guarantee, liability is limited by guarantee. C is a form of memorandum of association of company limited by guarantee and having a share capital. Now, those companies which are limited by guarantee, they can also have share capital. It is not that they will only ask the money on winding up. They can also ask money at the beginning. They can also have share capital. Table D is for the memorandum of association of an unlimited company. D is your unlimited company. And your table E is a form of memorandum of association of an unlimited company and having share capital. They can also have their share capital. Okay. We have learned unlimited company, guarantee company also. I hope you remember. The memorandum and articles of company must be as close to model forms as possible depending on the circumstances. As per the prescribed things that are given, you should make it in that manner only. Now, what will be the content in the memorandum? Let's see. Name of the company, name clause should be there where the name is to be mentioned with the last word limited, Reliance Industries Limited. In case of a public limited company, or the last words private limited company. If ABC private limited is there, they have to write ABC private limited. In the case of a private limited company, this clause is not applicable on the companies formed under section 8. Your charitable companies will not contain the section like words of private limited or public limited. The name including phrase electoral trust may be allowed for registration of companies to be formed under section 8 of the act. If you are doing a section 8 company, people are coming together and they are making a trust kind of thing, they can write electoral trust, ABC electoral trust. In accordance with the electoral trust scheme 2013 notified by the CBDT, Central Board of Direct Taxes. For the companies under Section 8 of the Act, the name shall include the words foundation, forum, association, federation, chambers, confederation, council, electoral trust, and the like, etc. So your Section 8 companies can take any name. Reliance Foundation, Reliance Forum, Association, Federation, these type of charitable names can be used. Okay, this was given in Companies Rule 2014. Is the name clause clear?
Yes, ma'am.
Okay. As per MCA notification dated 5th June 2015, a government company's name must end with the word limited. In case of one-person company, the words one-person company should be included below its name. So where you are writing A limited, you have to write one-person company. Below the name, you have to write one-person company. The state in which it is registered office of the company, registered office clause is to be mentioned. We saw that Karnataka changed to Mumbai. So that registration office clause is also to be mentioned. Objects for which the company is proposed to be incorporated and any matter considered necessary in the furtherance thereof. So we saw the object clause. So many objectives were given. So all these things are to be mentioned. If a company has changed its activities which are not reflected in its name, it shall change its name in line with the activities within a period of 6 months from the change of activities after complying with all the provisions as applicable to the change of name. I told you, Bata has started selling medicines. Earlier, it used to sell only footwear. So now they have to include in their name Bata Pharmacy, Pharmaceuticals. Right? They have to include that name. They have to change that name within period of 6 months from change of activities. You have 6 months of time to change the name. Liability of members of the company. Liability clauses to be mentioned. Is your company a company limited by shares or a company limited by guarantee or an unlimited company? You have to mention. The liability of members of company, liability clause, whether limited or unlimited, and also state in case of company listed by shares that the liability of its members is limited to the amount unpaid, if any, on the shares held by them. And in case of company limited by guarantee, amount up to which each member undertakes to contribute. Their amount also is to be specified. Like A is going to pay 5 crore, B is going to pay 7 crore. All these amounts that they have guaranteed should be mentioned. Undertakes to contribute to the assets of the company in the event of being wound up. When the company will be winded up or wound up, that time whatever amount you're going to pay, you have to mention. While he is a member or within 1 year after he ceases to be a member, for payment of the debts and liabilities of the company or of such debts and liabilities as may have been contracted before he ceases to be a member, as the case may be. Before he stops to be a member, before he discontinues, ceases to be a member, before that you have to mention all these things. To the cost, charges and expenses of winding up and for adjustment of the rights of the contributories among themselves. The cost and charges, whatever will be paid by the people who are guaranteeing the company, that is also to be mentioned. The amount of authorized capital clause, divided into shares of fixed amounts, and the number of shares with the subscribers to the memorandum have agreed to take indicated opposite their names, which shall not be less than 1 share. A company not having share capital need not have this clause. If the companies are having share capital, they need to mention a capital clause where they will be showing how the shares are divided into fixed amounts. Suppose Reliance share is divided at rupees 1000 per share. So they will be mentioning 1000 per share, name of the subscribers of the like the name of subscribers of memorandum will be written, and how many shares these subscribers are holding. Suppose this one holds 100, this one holds 200, this holds 5000, this holds 400. So all these details are to be given. And also you have to distribute the total share capital. We saw that there was a capital clause where the capital of 3.75 crore of Reliance increased to 15,000 crore, right? So that is to be mentioned over here. Then you have your association clause. In detail of the subscribers to be formed in a company, memorandum shall conclude with the association clause. Every subscriber to the memorandum shall take at least 1 share and shall write against his name the number of shares taken by him. So the subscribers need to take at least 1 share, and whatsoever is the number of shares taken by subscribers, it is to be mentioned in the MOA. In case of one-person company, name of person who in the event of death of subscribers shall become the member of the company, it is to be mentioned. If one-person company is there and the member who is the owner of one-person company, when he dies, who will become the nominee? His name is to be mentioned. Memorandum must be printed, divided into paragraphs, numbered consequently, and signed by at least 7 persons. 2 in case of private company and 1 in case of one-person company. And in the presence of at least 2 witnesses. Your MOA should be signed in the presence of at least 2 witnesses who will attest to the signatures. The particulars about the signatories to the memorandum as well as the witness as to their address, description, occupation, etc. must also be entered. You have to say if your witness is a professor in college and the other witness is a police officer. So these details are also to be given, where they live, what is their occupation, what is their description, they are Indian or foreigners, that is also to be given. Is MOA clear till here? Is it clear till here? Gopika, Meenakshi, Sharmita.
Yes, ma'am.
Clear.
Clear.
Okay. Now, it is to be noted that a company being a legal person can through its agent subscribe to the memorandum. If A Limited is a company newly formed and C Limited wants to subscribe to it, right? C Limited wants to be a subscriber of it, so they can appoint an agent and that agent will be subscriber to the memorandum. However, a minor cannot be signatory to the memorandum as he is not competent to contract. Minor will not be a person to the contract. He will not become a subscriber. Guardian of minor who subscribes to the memorandum on his behalf will be deemed to be subscribed in his personal capacity. If A is minor and A's father subscribes to A Limited, then it will be considered A's father is the subscriber, not A. Even if the guardian is subscribing, you can't say the minor is the subscriber. This person who is the guardian of minor, he will be subscribing in his own capacity, in his personal capacity. The above clauses of memorandum are called compulsory clauses. The clauses that we learned are your compulsory clauses or conditions. In addition to those, a memorandum may contain other provisions, for example, right attached to various class of shares. If the shareholders have different rights, they can participate in the voting. You can write that as an optional thing. But the clauses that we learned earlier, these are your compulsory clauses. Memorandum of association of a company cannot contain anything contrary to the provisions of the Companies Act. Your MOA should not contain anything contravening, anything opposing the provisions of Companies Act. Whatever is written in the Companies Act, Similar guidelines you can use for writing your MOA. You can't contravene it. You can't write anything in contradiction of the Companies Act. If it does, the same shall be devoid of any legal effect. Same will be facing any legal effect. Similarly, all other documents of the company must comply with the provisions of memorandum. Whatever documents of the company are making, it should comply with the memorandum. If in your memorandum it is written Reliance Industries Limited, all the documents should have Reliance Industries Limited. You can't write Reliance Limited. Okay, industries word, if you are using an MOA, then it should be used in all the documents. Is the MOA clear?
Yes, ma'am.
Okay. Now, should I go to articles of association or the doctrines? You people tell me what is to be done. Doctrines is something which we need fresh mind. Are you all like ready for that? Like no one is lazy or anything. It is not difficult, but it will need your like complete attention. AOA. Okay.
We can
Yeah.
start freshly tomorrow, ma'am.
Okay. Entire thing or like AOA should I explain now?
AOA explain.
AOA is okay na if I explain right now because we are in that touch.
Okay, ma'am.
Okay, let's just do AOA. Like I'll finish it up quickly because in your doctrine of anything ultra wires, or if you say, that is going to be a lot of things. So doctrine of ultra wires and doctrine of indoor management, I'll explain you completely in detail tomorrow. That will be very much beneficial if we do in the early morning session, like not very early, 10 o'clock, 11 o'clock will be good. Let's do it AOA. The articles of association of a company are its rules and regulation. Whatever the rules and regulations are there, that is mentioned over here. Let's first go to the articles of association of Reliance, and that then we'll discuss this. Now, are you able to see the screen?
Yes, ma'am. Yes, ma'am.
This is Articles of Association of Reliance Industries Limited, Table F excluded. Now, following regulations comprised in the Articles of Association were adopted pursuant to members' resolution passed at the annual general meeting of company held on 18th June 2014 in substitution for and the entire exclusion of the earlier regulations comprised. So these are the new regulations that have been given. Regulation contained in table marked F in Schedule 1 shall not apply to the company. So they have given some exclusions. Let's see what they have given. Now, they are giving articles means article of association. They are giving abbreviation, board of directors or board. They will be using the word board of directors. These are the directors. Company means Reliance Limited. Rules means rules given. And seal means the common seal of company. Now, share capital and variation of rights. Subject to provisions of the Act and the articles of board may issue and allot shares in the share capital. Whatever rules they are going to comply with the shares they have written. Directors may allot shares otherwise than for cash. Directors can give the shares otherwise than for cash. I told you, employees get the shares. So directors have the power of giving that share. Kinds of share capital, they have said we have equity share capital and preference share capital. Issue of certificate, we are going to issue the certificate and to the shareholders. Certificate to bear seal, all the certificates have the Reliance Industries seal. One certificate can share for shares held jointly. If two people are jointly holding the shares, we will only issue one certificate. Option to receive share certificate or hold share with depository. If you want to hold the shares with some deposits, you can hold it. Issue of new certificate in place of one defaced, lost or destroyed. If your share certificate is lost, we will give you a new certificate. Then power to pay commission, like company has the power to pay commission to the agents or to people who are holding the security. Rate of commission will be specified. Commission may be paid in how many days, how the commission will be paid. Members' rights are varying if there are any changes. Then provisions of general meeting are to be mentioned, issues, power of issue, further issue of share capital when we will do, how we will be issuing the shares, companies lien on shares, companies right on shares, when can we hold the shares with ourselves when someone has not paid the money, then can we give the dividend, and waiver of the lien in case of registration. If registration is done, what are the powers? And then validity of sale, how long the sale will be valid, like transfer of shares will be valid. Purchase to be registered holders, like purchase is to be done only to registered holders, those who are registered on the stock exchange. All these rules are specified over here. The call of shares rules are given, transfer of share rules are given, instrument is required for transferring the shares, when the shares will transfer of shares will be suspended, transmission of shares, forfeiture, when the company will forfeit the shares, take away the shares, that is given. Joint holders, if some people are joint holders, capitalization of profit, some profit we will keep it aside, or we will set it aside for future use, that is given over here. Buyback, when we can buy back the shares. General meeting provisions, all general meetings other than annual general meetings shall be called extraordinary general meetings. Board may, whenever it thinks fit, called an ordinary general meeting. Whenever the board wants, they will call an extraordinary general meeting, that is emergency kind of meeting. Then what will be the proceeding, how many people should be available in the meeting, all this is given. Minutes of meeting are to be recorded, what are the discussions done, they are called as minutes of meeting. So this is how more or less your articles of association works. All these clauses will be given, dividend, working, indemnity, insurance, general power, everything. Then subscribers details are given again, right? This is how it works, like for MOA and AOA. Okay, clear?
Yes, ma'am.
Let's see what
Yes.
content they have given for you people. The articles of association of company are its rules and regulations which are framed to manage its internal affairs. Whatever internal affairs are going to be done, whatever internal operations are going to be done, how we are going to manage is given in articles of association. Then what they have said, just as the memorandum contains fundamental conditions upon which companies allowed to be incorporated, so also the articles are internal regulations of the company. MOA consists on the basis how your company will be incorporated, and AOA contains how your company will be functioning internally. Guinness versus Land Corporation of Ireland has said that MOA is one thing where your basis of formation of company is there, and AOA is something how your internal functioning of company will be there. These general functions of the articles have been aptly summed up by Lord Cairns in Ashbury Carriage Company and Riches as follows. Articles play a part subsidiary to the Memorandum of Association. They act as a subsidiary to the Memorandum of Association. Hand holding, a subsidiary part, like they are the extra details about Memorandum of Association. They accept the memorandum as charter of incorporation, and so accepting it, the article proceed to define the duties of the company, rights and powers of the governing body, the powers that the government has against it, and as between themselves, whatever are the powers between the companies or any members of the company, employees of the company are given, and the company and the mode and form in which the business of the company is to be carried on. If you are only going to run an online business, you have to write that this business is an online mode and form, how you are going to do it. And the mode and form in which changes in the internal regulation of company may come from time to time be made. And you will also write, like if there are some changes required from offline to we are going online, or from online business only now we are going to open our retail stores, so that is also you have to mention over there. We will be changing on this thing. Document containing the articles of association of company, the Manga Carta, is a business document. Hence, it has to be construed strictly. It has to be made strictly. It regulates domestic management of a company. How the company will be functioning is written in articles of association, and create certain rights and obligations between the members and the company. It is going to create some obligations and rights to the members and the people who are going to run the company, like between the members and the company also. Article of association are in fact the bylaws of the company according to which director and other officers are required to perform their functions as regard to the management of the company. So whatever things the people of the company are going to do, directors, your employees, CEO, CFO, whatever work they are going to do is mentioned in your articles of association. Of the company, its accounts and audit. Whatever thing auditors also can do should be mentioned in AOA. It is important, therefore, that the auditor should study them, and while doing so, he should note the provisions therein in respect of relevant matters. So when we CAs go to audit the company, we also have to read the MOA and see what all things are written about the auditor. Section 5 of the Companies Act 2013 seeks to provide contents and models of association. Section 5 will tell you what will be the content and what is the model of articles of association. Section lays the following law. Contains regulations. The articles of company shall, okay, one second. The articles of company shall contain the regulations for management of company. You have to write down how the company will be regulated. What are the rules and regulations? Inclusion of matters. The articles shall also contain such matters as are prescribed under the rules. Whatever matters are written under the rule, that you can't transfer the share to an insolvent person. This is a rule given. So you also have to mention in your article of association. However, a company may also include such additional matters in its article as may be considered necessary for the management. If they want to mention any other of the provisions, any other rules, they can also mention. Like they want to mention that companies without having the share transfer certificate, they like the people without having share transfer certificate cannot buy or sell the shares. So that time also this matter can be included. Contain provisions for entrenchment. The articles can contain provisions for entrenchment. That means to protect something to the effect that specified provisions of articles may be altered only if conditions or procedures as that are more restrictive than those applicable in case of special resolution are met or complied with. So they will also put some points. They will also write some provisions to protect other points that they have mentioned, other specified provisions that they have mentioned. Manner of inclusion of entrenchment provisions. How you will write down the provisions to protect the earlier provisions. The provisions for entrenchment shall only be made either on formation of company or by an amendment in the articles agreed to by all the members of company in the case of private company, and by special resolution in case of public company. Now, if you want to make any changes in the provisions of protecting the other provisions, then what you have to do, you have to write it during the formation if you want, or else you can do it by amendments in the articles. And in case of public limited company, you need to pass a special resolution. A special resolution, you will be learning about types of resolution in your CA intermediate. For your understanding, I will tell you special resolution means your some particular percentage of people have to give their concern. They should be present while you are passing the resolution, and that is done in your extraordinary general meeting. Okay, till this first 4 points, is it clear to you people?
Yes, ma'am.
Yes, ma'am.
Notice to the registrar of the entrenchment provisions. You have to give the notice to the registrar that we are changing the terms. We are trying to protect us from this losses. If Reliance is facing some losses, Reliance had a company like which was for their telecom industries. Now Jio is made. Earlier they had some company. I'm not sure of the name that they had of the Reliance. Reliance GSM was there. So that time what used to happen, people used to do fraudulent activities, and then they used to take money and tell them like for this Reliance GSM SIM, you have to pay rupees 200. But in fact, this Reliance GSM SIM was selling for only 10 rupees. So 10 rupees SIM people were selling for 200 rupees. That time these things, fraudulent things were happening. So to protect the customers, to protect the people who are the stakeholders, who are interested in Reliance's SIM, what they did is they made an entrenchment provision. They tried to protect the people from this wrong. Now, when they were trying to protect it, they have to write it in their articles of association and also inform the registrar of company. Now, how they will inform, let's see. Where the articles contain provisions of entrenchment, whether made on formation or by amendment, company shall give notice to registrar of such provisions in such form and manner as may be prescribed. They have to inform the registrar of companies. Articles of a company shall be in respective forms specified in table F, G, H, I, and J in Schedule 1 as may be applicable to such companies. So they have to mention it in table F, G, H, I, and J in Schedule 1. Model articles, a company may adopt all or any of the regulations contained in model articles applicable to such company. If instead of Reliance, we are looking for Vodafone, Vodafone was existing earlier, and Reliance Jio is a new company. So Reliance Jio does not know what to write in articles. So they can take help of Vodafone's articles of association. They can use the model articles. Like we have our model test papers, mock test paper, we can take basis of that. Company registered after the commencement of this act. In case of any company which is registered after the commencement of this act 2013, insofar as the registered articles of such company do not exclude or modify the regulations contained in model articles applicable to such company, those regulations shall, so far as applicable, be the regulations of company in the same manner and to the extent as if they were contained in duly registered articles of company. Now, if you are registering a company after 2013 and you do not exclude, you write all the model articles and some extra articles of association, like some extra provisions you write in articles, then it is going to be a valid articles of association. Or else, if you are excluding some from the model articles, then it is going to be wrong. Okay, you have to include all the wordings that are given in the model articles. Are these points clear? 8 points clear to you people? Yes or no?
Yes, ma'am.
Let's see what is the difference between MOA and AOA. Memorandum of Association and Article of Association. Objective. MOA defines and delimits the objectives of the company, whereas Article of Association lays down the rule. MOA says your objectives and AOA gives your rules and regulations. Okay. Regulations of the internal management of the company. Articles determine how the objectives of company are to be achieved. Article will tell how we are going to achieve the objectives. MOA will tell objectives, how you have to do, how you have to achieve those objectives will be written in AO. Then relation between both. Memorandum defines the relationship of the company with the outside world, how your company is related with the entire market. It is given in memorandum. And articles define relationship between company and its members. What is the relation between company and the people who are members, your what you call it, employees, etc. Whatever is the relation is defined in articles of association. Then we have alteration. MOA can be altered only under certain circumstances and in the manner prescribed for in the act. It can be amended only in specific circumstances. You can't always amend the MOA. Okay. You have to take the permission also when you want to amend the MOA. Then what is said? In most cases, permission of the regional director or the tribunal is required. If you want to make the amendments, you have to take the permission of the regional director or tribunal. If you are in the Mumbai, your company is set up in Mumbai. So Mumbai regional director, you have to take the permission. Or tribunal, NCLT, you have to take the permission of NCLT. Articles can be altered simply by passing a special resolution. You need to pass a special resolution and then you can amend the articles. This point of ultra wires will be learning after the doctrines we have learned. Doctrine of ultra wire we'll learn and then we will learn the difference point. Okay. Now, would you like to continue with the doctrines or how? I'll pause.